Welcome to Forum 360 on Fusion, your PBS channel and your Rubber City radio stations. This is Leslie Ungar, your host today. In Tina Turner's famous 1993 song, she asks a simple yet potent question. What's love have to do with it? I could ask the same thing about the Constitution of the United States. What does it have to do with us, our lives, on a daily basis in 2016? 240 years after the Constitution was first conceived. What do 9, or in this case 8 people, all of whom have gone to either Harvard or Yale Law School, have to do with our daily lives? I think today we are going to find out the answer is quite a lot. In this presidential primary season, many candidates have name-dropped the Constitution. They've positioned themselves as experts, said that what they would do the first day in office in order to protect the Constitution, and they've pointed out how others have destroyed the Constitution. So this word Constitution and the concept has gotten more airtime than any one candidate. To help us understand the impact and effect of the Constitution today, I would like to welcome the former Dean of the University of Akron Law School and current Professor of Constitutional Law, Martin Belsky.
Thank you, Leslie.
Welcome and thank you for coming to help us, what I call us mere mortals, figure all of this out. So first, let's go back to the Constitutional Convention. Who wrote the Constitution and why?
Okay. Originally when they met, they were not intending to write a constitution. They were going to correct what they call the Articles of Confederation. And the real reason for the Constitution was to create a common market for the United States. It wasn't to cut up any Bill of Rights. Common financial market, like the European common market, because you had to pay a toll when you went from one state to another. You had to pay a tax from one state to another. So the whole purpose of the original Constitution was to create a common market. After they enacted a new Constitution and they voted on, they had to get it ratified. When they got it ratified, the only way they could get it ratified was a number of states said, we're only going to ratify it if you create a series of rights, a Bill of Rights. And those first 10 amendments was the way that they got the original Constitution to pass.
So why the Bill of Rights is the first 10 amendments to the Constitution? But if they were so important, why aren't they in the Constitution? Why are they amendments after the Constitution?
Well, because the original Constitution was only supposed to control federal power. And they felt that most of the rights that were given or denied were given by the states. So there really was no need. But the states were scared of the federal government coming in and stepping over on their toes. So they wanted to have protection against the federal government, because the first Bill of Rights only applied to the federal government. Didn't apply to states, didn't apply to cities, didn't apply to localities. So basically what they did is they wanted to put that in to protect themselves from the federal government. It was not in the Constitution, because the Constitution was dealing with national powers as compared to state powers.
So if you had to answer what role was the Constitution originally supposed to play, what would you say?
Economic unity. Simple as that.
And what role is it supposed to play today?
Well, today, as a result of the Civil War, we had a series of amendments, the 13th, 14th, and 15th Amendment, that basically applied most of the Bill of Rights to all governments across the country, state, local, federal. So now the Constitution is really a protection of individuals.
A protection of individuals. So as you've studied it, how can a document that is written over 200 years ago be relevant today?
Okay. I have to take a step back, because it might not have been but for a case called Marbury versus Madison. In that case, the Supreme Court said, we can interpret the Constitution as it applies case by case. It is not something that's just left up to each government leader to decide. There is one overarching authority, the Supreme Court of the United States, that decides how the Bill of Rights and provisions of the original Constitution are to apply. So when you have a problem, when you have an issue, and you want to challenge government, those decisions, called Marbury versus Madison and later decisions, said this is your forum to go into court and say, you can't do this to me.
Now, it's been amended 27 times.
Right.
So this document that you're talking about has been amended 27 times. At one time, the Supreme Court actually said that a slave was not a whole person, right? So if it's been amended and has the potential to be amended. How can one argue that it's the law of the land if the law changes?
Well, the law changes through a very detailed process. And also, by the way, it doesn't just change through amendments. It changes by a changing court who interpret the original Constitution. Why does it bind us? Well, we are, by the way, the first country that ever had judicial review. Israel now has it, and other countries now have it. But before that, there was no judicial review. There was no ultimate authority. Government leaders could do what they want, when they wanted. No one could challenge them. Why should we have that document apply to us? The reason we should have that document apply to us is we need some way to stop government from overreacting or overacting.
So it's really the judicial branch that is the be-all, end-all.
Right. Now, we'd like to believe that the President and Congress act in accordance with the Constitution. I call that constitutionalism. We'd like to believe that, and I think most of them do, most of the time. But ultimately, it's going to be the courts that's going to say, you can go this far and no further.
So while we think that the presidential elections or the Senate or the Congress are so important, it's really those people on the Supreme Court.
Yes, and of course it's the one that gets the least support. But this particular election, by the way, and this particular Congress, because the vote is 4-4 on so many issues, who wins this election and who are in the Senate is really going to decide the future of constitutional law for 20 or 30 more years.
Well, we're going to come back to that in a moment. First, let's take a look back. Is it true? I once read that justices used to stay in the same rooming house. The Supreme Court justices used to stay in the same rooming house. They used to eat dinner together. They used to socialize at night together. Is that true?
It was true. It's not true anymore. And the reason being that they used to meet for such short periods of time, and then they used to act as roving judges, each having their own circuit. So they would only be together for 6 weeks, maybe 7 weeks a year, so they would stay in a rooming house. Now it's a full year job, so they have their own residences right there in Washington. There is very little interaction between the justices now socially. They have their own little compartments, they have their own clerks, they have their own support team, and they really only communicate when they come together to decide on cases. Yeah, there's a few exceptions. Scalia and Ginsburg were very good friends because they liked opera together. Okay, Clarence Thomas basically doesn't do anything with anybody else. John Roberts, the present Chief Justice, really is more of a social person. He has been a judge for a long period of time. He has tried more than any other Chief Justice to get them to be friendly, associated, involved.
Interesting. But for the most part, because we hear every once in a while like that these two hunt together or they do, but that's really the exception.
That's really the exception, except for Scalia and Ginsburg, who really were close buddies. Completely opposite ideologically, but close buddies because of opera. That'd
be a kind of a good role model to follow, wouldn't it, in Washington?
Nice. Yeah.
Just the other day, before we take a look at more serious things, I have to ask you about this. A lawyer arguing in front of the what some people call the Supremes, referred to Justice Ginsburg as Justice O'Connor, who, by the way, retired almost a decade ago. Right. Tell us, as someone standing in the Supreme Court or arguing, how does that happen? I have to ask someone,
I've only done 3 cases before the Supreme Court, and you were terribly terrified. I can't describe it. It's like going before the altar of God. I mean, you see all these 9 people sitting there in this chair, and I don't care how many mock trials you get, I don't care how many mock arguments you're going to have. It is absolutely terrifying. So when you see a face and you look at that face, you know who that person is, but you might react by saying someone different. I don't think it's sexism. I just think you sort of get so scared and so panicked. Now, there are people who, including Chief Justice Roberts, who were there 50, 60, 70, I've only been there 3. If you're there 50 or 60 or 70 times, you're more comfortable. But you're terrified. It's really terrifying. It's like your first time you get up and give a speech. You know, whether if you're Catholic and when the first time you go up in front of if you're Jewish, it's a term how you bar mitzvah. It's really sort of, you know, it's terrifying. It's just terrifying.
Oh, that's kind of good to know.
It is.
These lawyers can still get that scared.
Oh, sure.
Is that going to hurt him in any way if he called you the wrong name?
No, because most cases are decided on the briefs. The oral arguments are helpful. They clarify each other, but most time the justices are not talking to the person who's litigating. They're talking to each other. They're trying to convince each other by the questions and answers for that 5th vote or that 6th vote. So really it's a dialogue. Clarence Thomas, who's one of the justices, only asked the question, I think, once in the time he was there, because he basically has said publicly, when I go in there, I've read all the briefs, I understand the situations, I'm not going to learn anything new from these people in front of me. But he doesn't try to make the effort to convince his colleagues either. And I think that's because of the ideological break in this court, which is more severe than we've ever had.
So out of, you know, people referred to the 14th Amendment, the 10th Amendment, the 13th Amendment. What do you think Americans think is the most important amendment?
I think the First Amendment, freedom of speech, freedom of religion, freedom of expression, freedom of the press. I think on a day-to-day basis, that's the one that's going to affect them the most. The second, I think, is the 14th Amendment, equal protection, which includes the right to vote, the right to non-discrimination. The First Amendment and the 14th Amendment, I think, are the most important constitutional amendments we have.
Is it true that the right of privacy isn't anywhere in the Constitution?
No, we call it a penumbra, but that is sort of a combination. But the recent decisions of the court have said we're going to place that as part of due process. We're going to place that in the 14th Amendment due process clause, which says a person is entitled to due process of law. Part of the substantive due process is the idea to be left alone. So they've read privacy into the right to be left alone, into the right of due process.
So where does the right to be left alone or the right of privacy fit with security and terrorism issues today?
That's the balance. For any constitutional right, there always has to be limitations on that right. For example, the famous joke is you have a right to free speech, but you can't yell fire in a theater. Similarly, in a situation having to do with privacy and the right to be left alone, and the right to be secure in your papers, secure alone, search and seizure, there has to be some balance. Historically, national security and war have always been the counterbalance, where the court has said we're going to step in. Most famous case being, say, we can inter Japanese during World War II. Yes, it's segregation based on race. You need a compelling interest to overcome that, but national security and war is a compelling interest. I disagree with that decision, but that's the argument.
And is national security, if there's not really a war, does national security still?
Well, we've never not been in a war. I mean, the Cold War existed after the Hot War, and now we have a situation with terrorism. I can't think of a period of time where we've never been involved in modern era in some kind of an armed struggle. So that they always use that as a justification. I was going to say excuse, but it's not really an excuse. It's a justification. So I think we're always going to have that balance. And the problem today is so much of your life is so public or is accessible that basically it has a major impact on privacy.
Today we are looking at some things that perhaps the last time you really thought about the Constitution was in high school or college, but we're looking at that really living, breathing document, the Constitution, and we're looking at it with a constitutional expert, the former Dean of the Law School at the University of Akron, Marty Belsky. You know, one thing that I am somewhat entertained by and yet truly frustrated by are the presidential candidates. There are now less than the 117 I like to refer to of the Republican candidates, but there were so many candidates that would say, on my first day of office, I'm going to repeal Obamacare, I'm going to do this, I'm going to do that. And I always felt that perhaps the average person that's not a constitutional expert may not know what a president can or can't do. So if the Supreme Court has told us what they think on gay marriage, on Obamacare, on different issues, can a president, his first day in office, what can he or she do about something that they may not like?
The answer to that, what can a president do? He can do a lot. However, he can't do everything. Matter of fact, one of the cases before the Supreme Court right now is how far the president can go on his own or her own, has to do with immigration. So basically, a president can make decisions within the scope of discretion he or she has.
Now, would that be executive privilege when you say make decisions?
No, not executive privilege. When the legislature legislates, the president, the executive executes, carries it out. So the question is, where is that line between legislation, writing laws, and someone who has the power to implement the laws? Most of what we do on a day-to-day is regulated by administrative agencies, determined by the president. The head of it said by the president. That line between law and regulation is very unclear. The executive action by the president is very unclear. The more we have become a unified country, the more we become a national country rather than a country of states, the more we have to deal with the international arena, the more power the president has, starting with President Roosevelt. So that more and more decisions are made by the president independent of Congress. Congress can always say no. Congress can always stop. But if they don't say no and they don't stop, the presidency has sort of come in and sort of gradually engulfed as much power as it can. And so we don't know the exact line, but increasingly more and more decisions are made by the president. Now, what decisions Congress can stop and what decisions the president can do? I don't think, for example, he can reverse Obamacare. I think a president, however, can say, I'm not going to enforce this, I'm not going to enforce this, I'm not going to enforce that. And I think the president can have a dramatic impact. President Nixon, for example, decided not to spend money on certain social programs. Just didn't spend the money. Just
so
didn't
that,
spend
in
the money.
essence, could close a program because they're not funded.
It can. And one of the articles of impeachment, by the way, Richard Nixon, was that he impounded funds that were intended to be used for programs. Didn't go anywhere because there's so many other things to do in that impeachment process.
Now, what about Roe versus Wade? Pro-choice, pro-life. Can a president come in and change what is right now a woman's right to have an abortion?
Well, it depends. If we have an open Supreme Court seat, and that president can appoint a justice in the Supreme Court, and the Senate approves that justice, he can absolutely, or she can absolutely change that decision. Because
the Supreme Court can, but not the president directly can. He can change it by who he appoints.
But he can pick someone he's pretty confident is going to make that fifth vote to change that stuff. Yes, it could. It's 4-4.
So before we go to 4-4, let me ask you this vacancy.
Sure.
And the presidential responsibility. You have the president on one hand saying it's his obligation to nominate someone, and then you have some other people saying because he's in his final year that he shouldn't nominate someone. From a constitutional standpoint, tell us how you see it.
All right. That famous legal philosopher, Yogi Berra, said where you stand depends on where you sit. If you are a congressperson, your belief is that you get to appoint, to review, to look at any nomination. So if you're a Republican, you want to see if you can get your guy in. If you're a president, you believe you have a right to appoint, and the Senate merely has to give advice and consent. They shouldn't interfere. Both are right historically. Both are wrong historically. But in the past, it has been almost deferential that you give someone, the president, the power to appoint. The Democrats did not stop, for example, Bush 1, Bush 2, Reagan, et cetera, from appointing someone. On the other hand, if you look back to American history during the Roosevelt days, there was some attempt to change, switching time saves 9, to change the court. There's no right answer here. I believe what this fight is over time, it's happened before, and it's going to happen. In fact, it happened to Garland, the guy who's there now. He didn't get his original appointment in the District of Columbia Court of Appeals for a year because the Republicans thought they were going to win the election in the second term of Clinton and be able to appoint someone in that court. So this is one of those games that goes on. I believe he's going to eventually get appointed.
And you believe that because if your crystal ball works, from your perspective, what's going to happen?
Well, I think there are so many Republicans in the Senate who are scared of Trump that they might decide, hey, somebody could be worse. Or after the election, if they see a Democrat come in, they think that, if it's Hillary Clinton or Bernie Sanders, that could be worse too. And Garland is a moderate to liberal. He is not a liberal. So they might turn around within, even right before the election or right after the election and appoint this person. And that's also happened before.
So it could even happen after the election?
Oh, yeah.
Because he is still president.
Right.
Now that we have a 4-4 possibility in decisions, it means that the verdict of the last court to hear a case will stand? Is that correct?
Correct.
Tell us what that means to us as citizens.
If there's a lot of appeals that go to the Supreme Court. If the Supreme Court does not reverse a decision, it stands. So you need 5 votes out of 9 to overcome a decision. If it's 4-4, whatever the decision was, the highest state court, the highest federal court below, that stays in place, okay, until you have, a decision. Now, what's happening, for example, in a case going on right now is they're arguing, don't decide. Don't decide. Wait a year, stay this, come back again. But I think the court's going to try to get that 5th vote, make it 5-3, or they're going to try to say we have to start all over again. And it's across the board. There's so many issues that are out there that are 4-4 that it's going to be interesting to watch the process work over the next few months and starting next year.
Let me ask you, just because we have so many other things to answer so quickly, being a Supreme Court justice is not the highest paying job in the legal world.
No.
So why is it something that people so aspire to and stay for life?
It's history. You're part of history. You make history. Everybody thinks they want to live after they die. And you are always going to be in law books. You're always going to be on Westlaw. You're always going to be on various things. You are part of history. You are making history. How many people can say in their lives they're going to make history?
And they do. Somewhere in the structure of the Constitution, there is a protection of civil rights. And it says that only the traitor can be punished. But one presidential candidate has called for families of terrorists to be punished. Is this against the Constitution?
Yes. It's a simple statement. You can't punish people under our criminal law for the activity of their relatives unless you can show they were involved somehow. They hid them. They helped them. They did something. If they have not done anything, you can't have group guilt.
So
no
just
such
saying
thing.
we're just gonna do this to families is against.
You can't now. That I have to say that the exception, of course, was World War II, where they were able to show national security in the war. I mean, the fact that the law says it can be done, and it can't be done, sometimes presidents, governors, mayors disregard it. We know on gay marriage situations, for example, we know some states are saying, or Bible reading in the schools, some states are saying, I don't care what you say, we're not going to do it. The courts have to step in.
And eventually that will work
Right, but remember,
through.
we have a society where we back up the courts. In some societies, the court can say do X, Y, and Z, and there's no enforcement power. But here, Eisenhower did not agree with the desegregation ruling, but he sent in troops to Little Rock. That's an unusual situation in the world, that we have an executive who's willing to go with the rule of law.
Obamacare is talked a lot about as being overturned, but the rule, as I understand it, is that legislative enactment is never to be disregarded or held invalid unless it is in excess of legislative power. So would that be used as a reason that it was in excess of?
Well, they're actually making three arguments. One, they're making the argument, which they won in part, which says you can't interfere with someone's free exercise of religion. And Obamacare forces some entities to give birth control and pro-choice kind of scenarios. That's one. Second of all, they say the president has overacted. He has interfered with states' rights, and so therefore the legislature did not have the power to do it because it interfered with states' rights. 10th Amendment of the Constitution protects states' rights. And the third issue is, you're right, is an improper delegation, some proper legislative power given to the executive. Again, all those are arguments can be made to the court. What's happened so far is the court has said there is congressional power. They have said that you can exempt certain religious organizations, and they have not yet decided about the delegation issue. So we're going to have to see. We're going to have to see.
Is abortion a fundamental right?
Right now, the court says yes, but
And what do you see in the next decade?
yes, but as blunt as I can say it, it depends on the fifth justices.
The First Amendment is cited a lot by what I call us mere mortals of freedom of speech. But there are a lot of caveats in that First Amendment. What is one thing that, let's say, the average person may not be aware of that we just don't have just a blanket freedom of speech?
You can't say things that are harmful to others, which has some physical impact. For example, there's a recent case that came down about someone who was promoting terrorism with their speech, their money, etc. And the court said the government can stop that. The government can stop that. So free speech has limits as long as you have a sufficient government interest, what they call a compelling government interest. Government can stop even free speech in appropriate circumstances. But basically, in our society, it's still a very broad right.
Now, what about the freedom of association with, the terrorism issues that we have? Do I have the right to associate with a terrorist if I wanted to?
The answer is yes and no. If the court finds there's a clear and imminent danger of what you're doing to cause severe problems, they can stop you from associating. On the other hand, they have to prove it's a clear and imminent danger. Not some danger down the road, not some danger, but a clear and imminent danger. And it depends. Some terrorist organizations have a clear and imminent danger, some don't. Lots of cases talk about how far do you have to go for that clear and imminent danger before they can stop you from associating.
In the first, in the Bill of Rights, in the first 10 amendments, are they in any particular order? Is freedom of speech, which is the first one, is that what was considered the most important, or are they not in any particular order from your perspective?
I would say that the First Amendment, which is the freedom of speech, freedom of press, etc. The Fifth Amendment, which is due process, the idea of sort of procedural rights and substantive due process. Sixth Amendment, which is criminal justice issues. And now, Supreme Court has said the right to bear arms, the Second Amendment. I believe the First Amendment is the most important for a democratic society. But there are various people who would pick other amendments as well. There are many people who pick the 10th Amendment, which is states' rights.
In just one sentence, how has the internet affected the free speech?
Dramatically, because the internet means that you cannot, how do you control everything all the time? So it means that people have a right to say things that when they were on TV they could control, on radio they control, in the press they control. How do you control 18 billion different kinds of ways to talk?
Will it ever be controlled?
No.
No. You heard it here first. Sometimes we may wonder, what does a document or rules made a couple hundred years ago by a group of old white guys have to do with our technological lives today? As smart as the founders of our country and the Constitution were, could they have foreseen America in the 21st century? Could they have known that free speech could be hate speech, the right to gather could be the right to do harm? Could they have foreseen the wireless world of communication and its challenges? Today, Professor Marty Belsky has helped us look at the world through the lens of the Constitution, its brilliance, its adaptability, its relevancy. Perhaps instead of thinking of it as something outdated or that doesn't affect us, we can now look at it as a role model of relevancy. I'm Leslie Ungar. Thank you for joining us today on Forum 360. Thank you to our guests and our viewers. Forum 360 is a global outlook with a local view. One last question. In 3 words, will we have a contested Republican convention that will go to the Supreme Court?
No, we will not. We will not go to the Supreme Court.
Thank you.
Forum 360 is brought to you with support from Electric Impulse Communications, Kim and Harvey Nelson, Rubber City Radio Group, Acronist.com, Hudson Cable, Medical Mutual of Ohio, Forum 360 supporters, and the Shaw Jewish Community Center of Akron.